Hey, Joe. All right. Let's stop the share real quick and see. Stop. There we go. Oh my God. So do video here because it's doing video over here. So just bear with me here. Let's use the different camera here. All right. Can you all see me? Because I can't see you because both of you guys, there we go. All right. So you can see me. And I'm just trying to make sure my live screen is working as well. And I think it is. Let's see if I can go here and see what people see. So they are seeing, yep, they are seeing this. So if they go to here, all right, we'll go share. And then I'll see my screen. Well, it looks like Crystal, are you Crystal, my cousin Crystal, or are you a different Crystal?
A different Crystal.
All right. Well, thank you for being on, Crystal. I didn't know because I got so many different crystals in my life. This is good. All right. And my cousin Crystal comes on a lot too. So gotcha. I love it, love it, love it.
Yeah.
All right. Let me just click on this. I'm not trying to share. I'm trying to set up the slideshow for you. So, Crystal, where do you live?
New York City.
Oh, okay.
Queens.
All right. Well, good, good, good. That's how. Have you lived there your whole life, or?
No, I lived in Harlem. I grew up there and then I moved to Queens.
Okay. So I'm not very familiar with New York. My twin boys that we had adopted were born in the Harlem Hospital, and then they grew up in Brooklyn until they were 4. And then we adopted them and moved them to California. So is Harlem and Queens, are they far apart? Are they pretty close, or
No, it's in Harlem, New York. In fact, my sister was born there.
Okay. Okay. Gotcha. And so are they, is, how far is Brooklyn from Queens?
Depends on where you're going.
Okay. The middle of Brooklyn and the middle of Queens, I guess.
Right.
And on a subway, does it take a long time to get from?
Again, it depends on where you're going. It can be.
Okay.
Maybe an hour.
An hour. Oh gosh. Okay. Gotcha. That, and then on traffic, I'm sure it could take you the same amount of time trying to
Yeah.
drive there. And then unless you have like a teleporter, like in Star Trek, then you can get
Yeah.
anywhere in the
That would be
world
nice.
pretty quick. Yeah, that
That would
would
be
be really nice. All right. So, hey Lex, how you doing today? I'm glad that you're on. I was just checking to make sure that it's
I'm just watching the live.
all right, cool. Are you, so is the live working? Just let me know. Is the live working on Facebook? And oh, nice. Okay, sweet. All
Yes.
right. So I like it, like it, like it. Is are we wait, Lily? Are we waiting for anybody else today?
I guess not. I invited quite a few, but I don't see them. So they said they would be on, or at least a couple of them did.
Okay.
I'll just keep inviting them until they show up.
I hear you. Well, I asked two people to get on today too, and they told me they'd both be on. So we will just get going because Crystal is in New York and it is 7 o'clock at night in New York. And it's only 5 o'clock here in Denver, Colorado. I know in Texas, Jill, where you're at, it's 6 o'clock. And I know where Sam's at, it's 4 o'clock. So we have all 4 time zones represented on this call, which is really cool. And so, Crystal, thank you for being on. I'm going to jump into and give everybody like another 60 seconds to get on, and then we are going to jump on. Oh, we also have Lexus in the Philippines. So we're not only have what's happening here in the United States, we have some stuff going on all the way across the world. All right. All right. So let me share my screen for you guys. So you'll be able
So
to.
since there are no guests on, are we?
Oh, Crystal is a guest. Crystal's a guest.
Oh, okay.
Yeah.
All right.
Yep. All right. So we're not going to pick on you, Crystal, because I have a feeling some other folks are going to show up. But we are going to talk about a living trust today. And so my name is they call me Dr. B. I'm Dr. Brian E. Arnold, and I have been doing living trust now for the last 21 years or 25 years now. Yeah, because I started in 2001, it's 20, so 24 years. I guess I'm able to do math as well. And I've had a fund of the thousands of clients that I've been able to help. And so one of the things is that when we think about a living trust and should everyone have one, the answer to me is absolutely everyone should have one, especially if you own a home. And there are a couple of items to start thinking about, and we're going to talk a lot about wills and trust today. And so whichever one is the best for you or the best option for you to be able to do, it is okay, but we all know that we probably should make sure that our stuff is taken care of for our kids. And so age is not a factor, as you can see. And I'm going to make sure you guys can see the PowerPoint, right? Okay. So age is not a factor. And so whether you're 30 years old or you're 92 years old, it doesn't matter. If you have assets that you want to give to somebody else, a trust or a will is the best way to do it. If you do not have a living trust, it would be most advisable to consider one, especially if you own a home, because we'll talk about some of those factors right now. So one that we do that I work with more often than not is what we call a revocable living trust. And basically when we say revocable, it means that you can make changes on it anytime that you wish to. So there's a lot of people, who always ask me, well, I want an irrevocable one because I don't want to make trust and I don't want to make changes, and I want to make sure that all my assets go. And there's times when an irrevocable trust is needed. It's usually when there is a disability or somebody in the home. Maybe you have a child that maybe have Down syndrome, and in case you passed away, you want to make sure that they're taken care of and the money is all in place to be able to do that. But once you make a trust irrevocable, that means you can't make any more changes to it. So for most of us, let's say I just turned 60 in March, and if I were to get an irrevocable trust right now, and let's say I bought a house when I'm 65, I couldn't put that into hey Janice, how you doing? I couldn't put that into the irrevocable trust. I would have to figure out a way to redo it, and it's super difficult. And if I moved out or refinance, and for most of us, life happens. And so because life happens, we want to make sure that we have the ability, if it's our trust and we're the trustee of the trust, that we can make changes if we want. So, but if you want to discuss an irrevocable trust, we can do that here in the future. But one of the things that is so nice about the revocable trust is you are the owner of your trust, and anything that changes in your life, we want to make sure it happens in the trust. Another thing that we do with our living trust, and some attorneys do and some attorneys don't, is in case you become incapacitated. That means you're still alive, but there might be some way, you might be in a coma, or you might have a breathing tube, or something isn't allowing you to make those decisions. We pick an individual in what we call a durable power of attorney for healthcare, and another one for finances, two separate people, because not everybody who's going to take care of you with your health is good at your finances. And everybody who cares about your finance, maybe not good at your health. And so we'll pick two different people. Sometimes it's the same person that can take care of those things for you. And then it reduces the cost and time to move your assets to the next generation. One of the things that happens is once we do pass away, we want the stuff that we have that we accumulated all our lives. And some of us have houses that are full and we feel like we're hoarders sometimes, and some of us don't have very much, but we still want what we have to go to our heirs or to the people that we want. So it reduces the cost and time to move your assets and generations, and it helps you create that family legacy that you may want. And so one of the things that happens here, at least here in the United States of America, is we have a process for that to happen. And that process, we've all heard that term, it is called probate. And probate is a way that legal title property is transferred from you to your beneficiaries. And sometimes it's a very pretty and easy and no problems process, and sometimes it can be very difficult process. For our trust, and for any of those looking into it, we can do, here at Metro Funding Group, we can do trust in 49 out of the 50 states. We cannot do Louisiana, and the reason we can't do Louisiana is because they are still under what we call Napoleon law. So this process of probate started 500-600 years ago. And so the British did it and the French did it. And then when we came to America and started our Constitution, we just kept the probate laws from those two countries. And we've had some, changes over time, but for the most part, probate is a public process in which every will, and you'll hear us talk, I'll hear me talk about us. You'll hear me, there's not two personalities in my head right now. So I just want to make sure I'm not talking, when I say us, I'm thinking about Metro Funding Group, not Brian Arnold 1 and Brian Arnold 2. And so what happens is it public? And so folks can go to a public probate hearing and they can make a claim against your estate. The story I love to tell is I have a friend named Reggie. I need to get Reggie on one of these calls one time. And Reggie's mom had passed away back in 2001 when I first started doing these. And she wrote a will, because all wills are probated. She wrote a will, and because we'd asked her to do a trust, but she said she'd rather just do a will. We weren't going to argue with her because we were new. We didn't know a lot about probate and that kind of stuff, but we found out pretty quickly. And so she wrote a will. She said, I would like for, and you can do a handwritten will. So literally, she wrote it on a spiral notebook. She said, I would love for my daughter and my son, Dana, and my son Reggie, my daughter Dana and my son Reggie, to get the house when I pass away. And then she had it notarized, and it was legal binding contract. She put it in a drawer. They found it when they got out. The problem that happened is she did pass away, and then she had a renter who was renting like a mother-in-law quarter right behind her house. And when that happened, when she had that mother-in-law's quarter and that happened, the guy who was living there said, you know what? She told me, I took care of her the last 2 months of her life, and she told me that I could have the house. Well, he took that over to the judge. He told the judge that. And then that probate now took 3.5 years for them to go through before they gave Reggie and his sister. And that man who was in the back house moved himself up to the front house, didn't pay any utilities, didn't pay water, lights. He didn't pay, trash. He didn't pay anything for those 2 years. The sister and Reggie did, while he lived there for 3.5 years before the judge finally awarded it. And public means anybody can go make a claim. And there's so many cases where, let's say I go in and something, Jill had passed away, and I said, well, Jill owed me $3,000 for some work I do. Now Jill's family has to prove either that I'm right or wrong. I just get the $3,000. Well, they have to decide, well, will I spend $5,000 on attorneys, or will I just give Brian the $3,000? So there are people who will look in the paper, and when they look in the paper, they realize, hey, somebody's had an estate. I'm going to go make a claim against the estate. We don't want that to happen. In the different states, it's about $75,000 worth of assets. So if you own a home, most homes in America are valued at more than $75,000. That triggers probate. When somebody passes away, what happens if they pass away at home is they will take your body over to the coroner. The coroner will then see if there was some nefarious stuff going on. And if there was not, he will issue death certificates to the family. Whoever's in, the family that shows up, he will give them 6 or 7 death certificates. And then what he will do after that is they will send a copy of that to the county in which you live in or where you passed away. When that happens, then the county takes it. And when the county takes that death certificate, they look to see if there was a time or a place where you had $75,000 worth of assets. And if you do, they're going to say you go to probate. So they will call probate attorneys. They will have them call you, and the process of that counts. Well, if you have more than 75, most of the states take at least about 8%. And we can get a chart that says which state costs which, because they're all, their fees or some administrative fees. And, they won't call it like a tax, but they will call it an administrative fee. And it's about 8%. Here in Colorado, if I had $100,000 worth of assets, then the state of Colorado would want $8,000 before we even get started. And so we want to avoid that if possible. We want to avoid the long process of it. What triggers is, I said 74,000 here. Here's who wins: attorneys, because you got an attorney that's the probate attorney, then you have your attorney, and they all charge you. The last person I talked to, they just went through. In fact, they were a person that's on the team. I don't think they're on today, but their mom. Oh, this is such a sad, and Crystal, I'll tell you, I was just heartbroken when this happened, because we put together a trust for this family, and it's for the mom, and the one of the daughters and her husband had paid for the trust for the mom. We had it sent over to her house. Now they're in Florida. Had it sent over to their house. We had a notary scheduled to go over to the house to sign. The notary goes over to the house to sign. The brother shows up and says, I don't want my mom to sign this. And the mom says, why? She says, because I got another plan for you that's going to be better. So let's just do that. Don't sign it. Don't do anything. Well, that was about 8.5 months ago that we did this. And so I said, okay. And we took, we refunded the money, and the family just went on without having a trust. 6 months later, or no, it's 3 months later, the mom has a stroke, and now she's in the hospital. There's no trust. The brother didn't do what he said he was going to do. Now they're trying to rush and do what the brother said to do and get some other kind of trust. The notary, they put new documents together. The notary gets over to the hospital 1 hour after she passed. And now it is going to probate. So instead of that trust that she could have signed when we did it to avoid probate, now the whole estate goes to probate. The attorneys cost $25,000 to probate it. All she had was a house and a car. And then it took 5 months. And they just told me last week they just finished probate to be able to do that. Had she signed it 8.5 months ago, was already prepared, we already had it done. I said, just sign it. And then if you get the other stuff done, it will supersede. They decided to wait. And that's what happened. And so we don't want that to happen to you guys at all, which is just, just so sad that happened. So the average cost is about 10% of the gross estate. Things that go into probate that they consider are CDs, brokerage accounts, IRAs, 401ks, certain types of life insurance, some annuities. Some of those will go to the beneficiary. Some of those go into a probate court hearing. To avoid probate, the thing that we can do is called a living trust. And the thing that probate takes is about 6 months, like I said, and it can be super, super stressful. Well, one of the things that people say, here's what I'm going to do to avoid probate. So we have the one where the son came in and said, we're going to do something different. And I think what he wanted to do was tell mom to quit claim the deed to him. And then that way her house wouldn't be probated, because that's absolutely true. If you put your son or your daughter or somebody else on top of your deed or on your deed, you quit claim it to him. Well, of course, then it can't go to probate because they're still alive and it goes straight to them. Sometimes we call that the poor man's way to make sure that the asset transfers, but there are some major serious problems with putting your kids on your deed. And if you've already done it, it's okay. We can fix it. We can make it change. But the first one is you lose control. I just talked to a person who said, I put my son on my deed. Now we want, my daughter was telling me, my daughter Martiana said they put the son on and now they want to refinance and the son won't let them. He said, if you refinance, it's going to lose the equity that I'm going to inherit. And so he won't sign off of it on the quit claim deed. And so they're not able to refinance their house to get some more money. So you lose some of that control by putting your kids on. They might think that you're senile, you have dementia, or maybe you don't. They just might not, just in this case, not want to allow you to sell your home. Because it needs everyone who's on the quit claim deed signature. What if your kids get in an accident? I've seen this many times in the 25 years where the son gets into an accident. Now he's being sued for the accident that he's in. And as a result of being sued, oh my gosh, as a result of being sued, they come after mom and dad's house because mom and dad put son on the deed. And now they have to prove that, that they might be some money come after it. Son doesn't have any assets when mom and dad do. They have a paid off house that they can sue against. So you don't want that to happen. A divorce, in our society, we're over 50% divorce rate. And so if your kids get are married when you put them on the deed and then they get divorced, well, at the time that they were married, at the time you put them on, because of most states are community property, that would mean that the divorced ex-spouse has claim to your house after you pass away. We don't want that to happen. What if your son or your daughter, whoever you put on there, stops paying their creditors? They want to come after you. Here's the big one, is taxes and capital gains. So let's say I put my son on, I'm 60 years old. I put my son on today onto our house. We live for another 25 years. So my house goes up in value from, $800,000 now to $2 million 25 years from now. That capital, $1.2 million in capital gains, because I put my son on there, when I pass away, he is now responsible for paying those capital gains on my home because I put him on the deed. Whereas if I don't put him on the deed, he gets the inheritance tax-free. So if there's anything you got out of this portion of my presentation, is don't put your kids on your deed. I will say that one more time and then I will leave it alone. Don't put your kids on your deed. All right, at this point, I want to just kind of pause because I know I've said a lot, and I want to see if there's anybody that's listening right now that has any questions that you would love for me to answer. Going once, going twice. All right, well, I'll just kind of move on to into the presentations. So the living trust that we do, so you have a choice. A will promises probate. A will does not avoid probate. A will makes sure that it's going there. A will is better than nothing at all because at least the judge knows something about your wishes. but if you own property, you should have a living trust. Now, I know this isn't taught anywhere by hardly anybody because 7 out of 10 people who own homes don't have a will or a trust. We are missing the ball, and the probate courts love it because not only does the state make money, the attorney who probates it makes money. The people who lose again are the family members who have to give some of that inheritance to other people that if they knew a trust existed and knew that they needed to take care of it and didn't procrastinate on it, that then their estate would go to their heirs without them having to deal with all the stress. So what we do is we make sure that you are in complete control of your assets. That's why it's revocable. It does not change the way you do taxes. Just because you hit, some people think, well, and there are different types of trust. And some people think about any kind of trust, nobody can ever sue me and I don't have to pay taxes. I don't know of a place that you can do that you don't have to pay taxes. There's some things where you can have tax deductions that reduce your taxes, but taxes are always due, and then you have ways to reduce it. And so it does not change the way you do your taxes. The trust does not protect you from a lawsuit. And so when we think about, well, somebody fell down on my property, I have a trust. Well, they can still sue you. That's why you have homeowners insurance, so they won't. The trust does not protect you from a nursing home. Somehow some people think, well, if I'm in a nursing home, then they can't come after me for anything. No, a trust doesn't protect you. A trust simply avoids probate, revocable trust, so that your assets transfer to your kids without that. And if you want to talk about other types of trusts, we could do that at some point if we needed to. So what happens with you pass? I already talked about that, the process. But what happens if you have a living trust and you pass? The immediate asset goes to your family within minutes after you pass away. It's private. So that person who was in that back house in my story earlier, that person in that back house could have showed up at court and the judge and him would have been sitting in court by themselves because it never would have went to probate. They could have tried to sue against the estate. This is what her wishes were. So it doesn't happen. It's inexpensive compared to what you're going to pay for attorneys. The stress goes away. My grandpa passed away, and I did do a trust on my grandpa. And my mom has 11 brothers and sisters. And grandpa passed, and grandma passed, and all 11 of them came home for the funeral. After the funeral, they went and sat at this big table outside the house, so they could talk about what was going to happen with my grandpa's estate. And they literally started arguing a little bit. Well, he told me I could have the car. And my other uncle, well, he told me, I was going to take the tractor. And so my grandpa had a farm. So there was a lot of assets as part of the farm. It was a dairy and that kind of stuff. It wasn't an active dairy, but there were still equipment. And they were arguing over an air compressor and all kind of stuff. And my mom went into the house. She knew exactly where grandpa had put the trust that we put together for him. She brought it out. She set it on the table and she said, this is what Papa wanted. And even if they were mad, there was nothing they could possibly do because these were my grandpa's wishes. And whether it was split equally, it wasn't. They had nobody to complain to other than asking their brother, do you think, I know he gave you that rifle, do you think I could have it? That kind of stuff was now they were bartering instead of being angry and arguing. People just act great. Families act crazy when somebody passes away. My mom had a neighbor, her name was Donna, and she was married for 57 years to her first husband, his second wife. And he passed away, and he had 3 children from before in his first marriage, before he married Donna. He's married to Donna for 57 years. She is now super sad. After the funeral, his kids went to U-Haul, backed up to her house and started taking stuff out of her house. Now, you can't tell me after 57 years that absolutely everything in that house was both of theirs. But as a result, that's what families do. So a trust protects that part of the stress that goes there. And again, I want to reiterate, there is no probate. Now, when that death certificate's over to the county office, the county office looks it up and they go, oh, it says the Jill Butler Family Trust. Oh, all we can do is move this file to done. There's no probate. There's no probate attorneys. There's nobody to call. There's no nothing. they don't even do anything with that file when they see the word trust in there, because there is no probate. All right, so our living trust, the ones that we get, we have what we call a trust agreement. That's the beginning of the trust that just says this is a legal binding document that is recognized in 49 out of the 50 states that are the United States of America. And I think it even works in like Puerto Rico and maybe a couple other territories. The durable power of attorney for finance avoids conservatorship. And so if you've ever been in a spot where family's arguing on what to do with a loved one, oh my gosh. And then a judge has to decide who can make the medical decisions because they can't make my daughter Martiana's husband's dad had a stroke almost a year ago now. And he had a second wife. He told his second wife, if I have a stroke and I'm brain dead, please don't take me off of life support if it's more than 72 hours. I don't want to live on life support. He told that to her, but who he didn't tell was his daughter from the previous marriage that he had. And so that thing was like 3 months of her saying, I want to keep my dad alive. And the wife saying, no, he said he doesn't want this. And who's winning in that? The hospital, who is now racking up a bill on him staying on life support, that beyond what the insurance is going to pay. And so we want to make sure that the judge doesn't have to make that decision. That's for healthcare. Finance, same thing. Who can, if you're incapacitated in a coma, who's going to pay your bills for you? We talked about the living will, with life support, HIPAA release, who can see the record, especially if they're not an immediate family member. We have what we call a pour-over will. And what a pour-over will says is that the minute we get the trust in place, it's notarized, and what we call funded means if you get something else and you buy something else, and you meant for that to be as part of the trust. And so immediately, whatever you put into your trust, that's how that asset will be disseminated. So let's say you go buy a car and you're on the way home, or a motor home or something, and you're on the way home and you get in an accident and you pass away, and then the insurance decides to fix that car. Whatever you said in your trust is who now gets that asset. Not, somebody making it up. You didn't have a chance to maybe add, a grandchild or something like that. And if you don't do that, it automatically reverts to the trust. That's what a pour-over will does. We do what we call a deed transfer. So we make sure that if you have deeds to your house, it goes to the county. We call that funding. And it says now it is no longer in the Jill. I don't know why I keep using you, Jill, but it goes to the Jill Butler, property with rights of survivorship to somebody else, tenants in common or something like that. It says the Jill Butler Family Trust, and we make sure that it's there so that the court knows that it's no longer part of them. All right, so I already kind of talked about the durable power of attorney for healthcare. These are just reiterated. If you want copies of the slideshow, they are available on our site, and so I'll make sure you get a copy if you want one. I talked about a living will, and it's just a legal document, details how you prefer to receive medical treatment. It's just not don't resuscitate. It's please give me a sponge bath because I don't want to stink. Or please, allow a person to come in and give me a massage. Or please, don't feed me through a tube. Or don't put me on a respirator. There's a whole lot that goes into a living will that's not just do not resuscitate. I know some of the stuff we don't want to talk about. But once you talk about it once and you got it taken care of, there's just a piece that comes about you that says, I don't have to worry about that anymore. I know my stuff is taken care of. My kids are going to get what they're supposed to. Now the kids can come over and they can argue with you, please give me that, or please give me this. But at least you've taken care of it, right? And so we talked about a pour-over will, talked about a deed transfer. You'll see on here where it says funding a trust. And this is the term to describe ownership transfer. So we make sure that your trust is funded and the assets that you have. I had so many people that have gotten a trust from maybe an attorney or somebody else, and there's a little small print that says fund it yourself. And then they pass away and they go, whoops, going to probate because this trust has never been notarized. And the deed has never been put into the trust. Some attorneys do that because now not only did they get the money for selling you the trust at sometimes twice, I'll just tell you this, twice as much as we charge for a trust. And whoever invited you here, they can talk to you about our prices. But twice as much. and then they still want to probate it because they make way more money on probating a estate than they ever can do on selling you a trust. I mean, like 10-fold, 20-fold, 30-fold. They say, like, we have a firm here called Hughes Law Firm. They've done about 80,000 trusts since 1979. They start at $3,000 and go up to $5,000. At their $5,000 levels, kind of their minimal, and you think $5,000 is what they paid to do the actual living trust. But if they get to probate it, if it's not funded, they're going to charge $25,000. 10 times or 50, 20, 30, $40,000, 5 to 10 times as much. So we don't want that to happen. And so that is my presentation. I kind of stop it here because I can really geek out on talking about all these things, and that you could just, like, your head will go back and then your eyes will roll back in your head. And I don't want that at all to happen. So I want to make sure that now, if this is what you're thinking or what you want, or you have questions about it, I want to answer those, and then I can get detailed on some of those questions if we do that. So who here has a question for me?
I actually have a question.
Okay.
Dr. B, just for clarification purposes. So because the trust has the pourable will built in,
Mm-hmm.
has there ever been a situation where you suggested, or it's been suggested, that a client not only get the trust, but in addition, get a separate will?
I have not been there once the trust is there, because the trust has a last will and testament in it, and it also has the pour over will. So I have not seen with the trust where there would be a reason to get a separate will, because anything that can be put in the will can also be added to the trust. Now, on the opposite of that, everybody who has a will, I'm saying you should get a separate living trust, because it's going to protect you a whole lot more than a will would. But I've not seen yet in my experience where there would be a need for a will, because whatever document was notarized last becomes the document of record. And so if you went and got a will, I guess the will said, do everything that I said to do in my trust and notarize that. That would take care of anybody who would try to contest it. But it would just assure that, it's not going to probate. So the trust is that extra step, that says, yeah, you don't need to do a will. Great question,
So
though.
then, one other question. So for individuals, say for instance, if individuals, they have a will already established, but on all of their financial accounts, insurance, 401k, any type of brokerage accounts, checking, savings, they have beneficiaries listed on everything. Is it still, what are the chances of things going through probate if they have a will, if everything is listed with beneficiaries?
What's the house that they own?
There's no house.
Oh, there's no house, and they just have everything with the beneficiary. It just depends on if there's an account that didn't have it. But yeah, if there's a beneficiary on most of it, it may not go to probate, but it'll go to probate, and the probate judge says we don't have enough to do anything. So that's what will happen. But here's what could happen is somebody can go in there and protest it. Because it's going to probate, somebody could go in there and say, you know what, I know they have a beneficiary that's written on that, but they told me they were going to make me the beneficiary. And they didn't get to it for whatever reason. Now it's up to the judge to make that decision. Because it's still, with all of those, it's going to go to the probate court. And so as long as nobody makes a claim against that estate, you're okay, even though there's beneficiaries on everything. If it never goes to probate, nobody can make a claim against it.
And can I just ask one more
Sure.
question then? So one of the things that you mentioned it, you didn't go in great detail, but regarding special needs trusts, is there resources that are available through Metro Funding Group for people that may need a special needs trust?
There is, and so it's one of the things that we do, and it just depends on how in depth that special needs trust is. For some people, they want to have the trust, but they don't have funds to actually take care of. If they have funds that are going to live throughout the person's life, then we might go beyond, and our attorneys can take that on and help them there. If they don't have funds and they're just on like disability, that kind of stuff, and that's what's going to continue, then our trust will work just fine for that. But what we want to make sure we do is we don't want that beneficiary in the special needs trust to inherit a whole bunch of money and lose their benefit. They lose their disability benefit because all of a sudden they have all this money, and the disability, Social Security Administration goes, wait a minute, we see they have $100,000 in the bank, and because they do, we're not going to award disability anymore. So we make sure that that gets put into a different trust in order to make sure that it is not part of their money, and there's somebody like an executor who's in charge of that trust and can disseminate the money as needed for that child to be taken care of.
Thank you.
Absolutely. And the other would be like the house. That's another thing that a house would, they can live in the house as long as they're alive. Like my sister, I have a nephew who is autistic, and in my sister's trust for him is he gets to live in that house until he passes. Nobody can sell it until he's there, unless he figures out a way that he can move out by himself and take care of himself, and he does he wants to sell the house. But as long as he's alive, which will never happen, but he's like 30 now, and as long as he's alive, that house has to go to, and she has put money aside for him to pay the taxes and the insurance and all that for all the years. She has a life insurance policy that will take care of the stuff that's not, that the house is paid for, but he gets to live there, and then that will pay for itself. Cool. Hey, James Young, how you doing today?
I'm fine, and you?
Good. You have a question?
For
Sure.
you. Sorry for joining late.
Oh, you're fine.
Something I was doing. So a question for you. And I know a little bit about trust, but let's say the trustee dies or executive estate, whatever. Does a trust go on in perpetuity, or how does that work?
No. So the trustee passes away. You're talking about the person that they've named as executor passes away before or after?
So if whoever I leave it to, the executive estate, the trustee, whatever, if they die before I die,
yeah,
right?
Mm-hmm.
If we both die in a car accident, let's say, then what happens?
So we on our provisions, we have a secondary one that's named in case that does happen. And then if not, no, the trust has to be decided who is going to be the executor. It usually goes to one of the other beneficiaries who can decide. If the family decides that person is okay and everybody agrees on that person, then they can just make that person the executor. If in fact they can't agree, then they can take it to a probate court and a judge can name a new executor for the trust.
Okay, but so who safeguards the paperwork? So, like, let's say I have my trust pay out to a nonprofit scholarship for my family, right?
Mm-hmm.
And I want it to go on for 10 generations. Who's going to hold that paperwork? What is a law firm that's holding it goes out of business? I mean, how does that work?
Yeah, somebody else has to decide who's going to take over. That law firm goes out of business. That law firm usually names who takes over their accounts.
Oh.
If you're paying, yeah. If that's what you have for 10 generations, yeah. And for 10 generations, they probably will go out of business. And so
it's a stupid question.
No, it's not. It's a great question because that, you're thinking about that, that's where you're really starting to think, when we think of like the Rockefellers and we think of some of the, the big ones there, they literally have life insurance policies and a set of attorneys that then pass it on. And their life insurance on every person in that family that's born is a mandatory life insurance policy for millions of dollars is put on that person as soon as they're born. And then when that person actually passes away, those millions of dollars then go to, back into the estate. So the beneficiary of those policies that are written are the estate. So the state can never run out of money. It goes on in perpetuity forever and ever and ever, as long as people are being born. I guess if nobody else is being born, then there's no life insurance that's being purchased. When there's no life insurance that's being purchased, at some point that money will run out. But the amount of money that's in those accounts right now, I don't know if it could ever run out.
Thank you.
Absolutely. Anybody else have any questions? All right. Well, I will encourage you to get with the person who brought you on today and or invited you to this. And they can sit down with you and then go over pricing and they can go over all those wonderful things that I can get you planned. They will give you my number if you need it in order to get a hold of me if you have any other questions that you think of, because we all do. We see a presentation and we go, I don't have anything to think about right now. And then as soon as I turn this off, about 15 things come into your mind. So we want to make sure that those all get answered for you. I am doing this every Wednesday night at the same time. And so if you think of questions and they're just not getting answered and you just want to listen to this one more time, please join us again. I'll also record it. We continue the recording to this particular one. And I hope you guys have a wonderful, amazing, awesome, incredible day. I'll give one more chance for any other questions. 5.
I think Chris is new here, right?
Okay, but if he doesn't have any questions. Okay, for the folks that are part of our team, we're going to hang up right now, and then we're going to get back on in 5 minutes to do some training. So we will look forward to talking with you guys then. You guys have an amazing, awesome day.
Thank you. Thank you, Crystal, for joining today.
Yes.
Okay, good night. Talk to you later.
All right.
And then I have to figure out how to end this meeting. Come on, Brian.
Recording stopped.